All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Hey, good afternoon. Carl Rominger here, 540-0580, answering your legal questions. Of course, we're going to talk about Trayvon Martin and George Zimmerman here briefly, but not yet. We're going to get right into the calls right off the bat. As you know, I do a show here in the Mid-State answering your legal questions. You can always join me on Facebook. And, oh boy. I don't think Shane gave me my list of live reads today either. Bad boy. All right, we'll figure it out anyhow. 540-0580. Dave, you're on the air. Hey, Dave.
Hey, hi, Carl. How you doing?
Good.
You know, in the aftermath of this Zimmerman trial, I was just wondering, and I was discussing that with a friend of mine this morning, how does the castle doctrine affect me? Like when I'm in my house and I'm sitting on my couch, should I have a gun near me in case somebody breaks that bay window and comes in and gets me?
Well, I mean, let me put it to you this way. If your 4-year-old sitting on the floor playing, you probably shouldn't have the handgun sitting on the coffee table waiting for somebody to break in, right? So there's a balance there. The short answer is under the castle doctrine, and this is where things get confusing. People, for some reason, think the Trayvon Martin case has something to do with the castle doctrine, and the answer is it doesn't, because he was on the ground with somebody on top of him when he shot. Okay? Under the regular law of self-defense, before any castle doctrine was passed in Pennsylvania or any other state, under the common law right of self-defense, if you can't retreat, you may use deadly force. If the guy is on top of you, beating you up, then you cannot retreat. Therefore, you may use deadly force. No castle doctrine required. Okay? So I don't know why everybody keeps calling it a castle doctrine case, except that we all did that early on when the news media picked up on it. But now it's clear that he was shot while he was on top of him. Therefore, Zimmerman couldn't have retreated, so it's not castle doctrine. What the castle doctrine says in Pennsylvania is you have a presumption that deadly force is required when somebody breaks into your house, okay? That's important. You've already, the government not only has to disprove self-defense, but they have to now overcome the presumption that you were defending yourself. On the other hand, the castle doctrine also gives you the right to stand your ground in any place you're lawfully entitled to be and not retreat if the other person brings a deadly weapon and you see it. Otherwise, if you don't see a deadly weapon, you still have to retreat if possible.
Even if you're on your own couch in your own living
Well,
room?
no. In your house, it's different. I just told you that. In your house, you don't have to retreat in your house. But you've never had to retreat in your house in Pennsylvania.
I see. Well, I just moved to Pennsylvania a couple of years ago.
Okay.
And I'm getting used to this, but I don't have any children, just me and another adult.
Well, then you can keep a gun around, and then the other adult might shoot you someday in a fight, maybe. I don't know. But the short answer is you can certainly keep a gun around. And in fact, when I was not having a child in my life, I routinely had loaded handguns stashed in a few different places. And in my one closet, you could just pull on a piece of strap fabric if you knew what it was, and down comes a combat shotgun ready to go.
Did you ever see that movie Fargo?
Yeah.
And you remember the boy that maniac broke in that bay window, the front window, and came after that lady? And that's what bothers me. You know, sitting on the couch watching TV, and somebody knocks the whole window out, and you know that's what bothers me. That's why I think I probably should have a gun nearby, because having it upstairs in the drawer isn't going to help you.
It doesn't do you any good. That's right.
Yeah. Okay.
All right, my friend.
Thanks a lot.
All right, good luck. 540-0580. Mike, you're on WHP 580 with Carl Rominger.
Yes, sir. I have a property with someone, joint tenants with rights of survivorship. And I wanted to know if I could get out of it or they get out of it, or how do you go about getting out of it? Sell it? What if they don't want to sell?
All right. Repeat this. You own what with joint right of tenancy?
Two properties.
Okay.
With me and a female on them, and joint tenants with rights of survivorship.
Right.
I did a quit claim deed, added her name to them, And now I think I want to end the joint tenancy. And
well, but now you made her a joint tenant, then she owns half of it, right?
Right.
So is she willing to sign off?
I don't think so.
Well, my friend, once you gave her half, you can't take it back.
Well, I know, but can you say, well, we have to sell it since one of us wants to get out of it, or no?
You can force a sale of it, yeah. If she won't agree to sell it, you can force a sale of it. It's called a partition action.
Okay, that's what I needed to know, because one is a rental property that she's not even cooperating on, and another is a vacation house that she's using, and it's like I'm being cordial with her, but it's like I just want to end it, so I can force a petition of action then.
Yeah, it's called a partition action, and you go to the court and you say, hey, I don't want to own this piece of real estate with this person anymore. And if she's smart, you guys go list it with a realtor and be done with it, right?
Right.
But if she's not, then the judge will eventually auction it off.
Okay.
All right?
Okay. Hey, thanks for your time, and I can call you in Carlisle.
Yeah, absolutely, and I've done a lot of these over the years.
Okay, thank you,
All
sir.
right, take care, man.
Have a great day. Bye.
540-0580, Carl Rominger here answering your legal questions. Danny in Dillsburg, what's going on? Hey, Danny.
Hey, I'm driving right now. I have a little bit of reception. We have a partnership, LLC lawyer, the agreement.
Oh, you're cutting in and out, buddy. Well, Danny, I don't know. That was a good question, whatever it was. Well, let me just tell you guys, RJ Gold, and he's helping me out here. If you need to liquidate an estate or business, I recommend you call RJ Gold Auctions. He can buy outright or sell your items at auction. RJ Gold can be reached at 645-0061. He purchases outright items such as medals, pins, patches, tokens, awards, and badges, and most historical collectibles. He can pay you right away. RJ Gold, 645-0061, 3712 North 6th Street in Harrisburg, PA licensed auctioneer number AU005798. That's RJ Gold. And make sure when you call me, tell him Carl sent you. Again, the number is 645-0061. So if you need some extra cash, give him a call, or you want to know when he's having his next big sale, give him a call. Elaine, you're on the air with Carl Rominger. What's going on?
Yes, good afternoon, Carl.
How are you?
Good. I see in the paper all the time that they're having sheriff sales in the area that we live in. And could you explain that to me, what it means, and how far along is the foreclosure process?
Well, there's two kinds of sheriff sales. There's sheriff sales of personal items, okay? But we'll leave that alone for a minute. We'll assume you don't want to buy somebody's beat-up old colored television set. And instead, you're most interested in buying a piece of real estate. What happens is after the foreclosure action has been won, there's a judgment entered already, then you may go to the sheriff and list the real estate for sale. When you buy a piece of real estate at a sheriff's sale, you take it subject to any of the potential pitfalls with the title, okay? So you go to the sheriff's sale, and usually end up bidding against the bank, by the way, because the bank's not going to let it go for a lot less than what's owed on it, if that makes sense.
Okay. Right?
They'd rather make sure that they end up owning it than you. If $80,000 is owed on a $150,000 house at the sheriff's sale, the bank's not going to let it go for 15.
Okay.
They're going to bid up to at least what they're owed if they can. So the bank's attorney's almost always there making sure that the bank ends up with it. And I think they actually changed the rules to make it even easier for the bank to, in the last year or two, to make it even easier so that if the bank's lawyer's lazy and forgets to show up, they still have some protection. Imagine that. Their lobby's really good, right? So
certainly is.
So anyhow, what you should do if you're going to approach sheriff's sale the right way is you get the list ahead of time. And then you go and try to figure out what's going on with all the properties. Well, if you're not familiar on how to do a title search and the issues, you have to be careful. A lot of the guys and gals who do sheriff sales routinely will go to the courthouse and do their own title searches. So they learn how to do them efficiently, and they go through and they do every property so they know exactly what they might be looking at. And then they know. So if you're ever at a sheriff's sale or a tax claim sale for that matter, and you're like, why is nobody bidding this place up? It must be a real bargain. It means one of two things. Either they've physically seen it and it's decimated, or they know that what problems you're going to take it with when you buy it. You could accidentally buy yourself into an environmental problem as well. Anyhow, long story short is once you kind of know about the history of the property's title and their general condition, then you can go to the sale, the auction, and bid on them. The other thing you can do is instead of waiting for the sheriff's sale, is that's an opportunity perhaps to go to the bank or the defendant in the mortgage action and try to work out an opportunity to buy it there as well.
Is after a foreclosure then?
Correct. Or a tax. They do tax sales as well.
Okay.
Although that wouldn't be technically a sheriff's sale. There are also judicial sales. Those are the best place to buy a property. That's after it hasn't sold through the regular tax sale. Then you get a judicial sale, and those come free and clear of all liens. I got to go to break.
Thank you very much.
540-0580. All right, we're back. 540-0580. I tweeted that I was going to have Edward Snowden on to tell us what the NSA didn't want to know at 1:15. Of course, obviously, that was a little bit of a spoof. I just wanted to see if the signal still went out across the air and whether or not black helicopters descended upon the HP 580 studios. But alas, the NSA probably knows exactly where he's at and who he's talking to right now because they're listening to you on your cell phones right now. Oh, we don't actually listen to your individual calls unless, one of our analysts happens to be at his desktop and just wants to look up his neighbor, his uncle, a Supreme Court justice, or maybe even the presiding trial judge at the Zimmerman trial, right? That's all the things we're reading on the internet right now. Actually, there was people who were making a big deal of the fact that the judge colloquied Zimmerman on not wanting to testify. That's done routinely in court when a client, some judges don't do it at all. Some judges always do it, and some judges just do it in some cases. But generally, when I go into court and my client is not going to testify, out of the presence of the jury, the judge colloquies, which means has a discussion with, fancy word, the defendant to say, hey, what are you doing? Do you realize it's your absolute right to testify or absolute right not to testify? And it's your choice and your choice alone and not your lawyer's. The reason for that is defendants have a habit after they lose a trial of coming back to the court and going, well, my lawyer told me I had to testify, or my lawyer told me I couldn't testify, or my lawyer said I shouldn't testify and I wanted to, and he told me he wasn't putting me on the stand. So to prevent all that hullabaloo after the fact, judges like to colloquy the defendant. Some other judges don't do it because they don't feel it is appropriate because the defendant may feel pressure. Now think about this one. Here's the overlay. The client has said he doesn't want to take the stand. And then the judge gives him this stern discussion about, well, you sure that's what you really want to do? At least that's how he takes it and starts going, well, the judge must be telling me. And I've talked about this on this show before during a guilty plea, for instance. Sometimes when a judge is trying to be extra protective of the record or make sure the defendant really understands their rights, the defendant starts second-guessing his or her guilty plea going, well, I think the judge is trying to tell me not to plead guilty because they keep talking about trials and picking jurors and how I'm giving up so many important rights, and am I sure I want to give up my rights? And then they start going, well, I think the judge is trying to signal to me something. And the answer is no, the judge isn't signaling anything to you. But some judges don't like to colloquy the defendant because they believe that may cause a defendant to switch what they truly want to do because they're getting questioned on it. But I've never had an issue like that, and usually lawyers prefer a colloquy of their defendant, not a extensive, angry colloquy of your defendant, but a nice one on the record simply so that you don't have the problem of your client who's now sitting in state prison for 15 years trying to give you an issue. Ron, you're on WHP 580 with Carl Rominger. What's going on? Hey, Ron.
Okay, hi, Carl.
Good. What's going on?
Always enjoy your show.
Thank you.
I was just curious, and obviously you've already stated a few things, but if you were following the Trayvon Martin, George Zimmerman trial much, and there's an attorney named Mark Levin, I'm sure you've heard of him, that kind of said some pretty insightful things about the judge, and I just kind of wanted to know your take on that whole trial.
Yeah.
Briefly.
Well.
I know it's hard to say briefly on that one, but
let me ask you this question: tell me what you heard about what Mark Levin said, because I'd be curious. I mean, I heard some of it too, but help the listeners out here.
Well, actually, I just read a brief thing, and it was just that he thought that the judge had done some things that may be improper, and but I didn't really get to read much extensively on it. So
yeah, he has called out basically. And I'll give you an example. It's in today's news, okay, and I posted it on my Facebook page. The prosecutors fired the guy who leaked. Nobody likes leakers these days. They fired the guy who leaked that they were hiding evidence from the defense. So this was a guy who worked for the prosecutors, did the technical work, and became aware that all the material he'd removed from Trayvon Martin's cell phone, which included pictures of Trayvon with guns and drugs and texts suggesting criminal activity and things like that, had been withheld from the defense. And at the eve of trial not too long ago, that was discovered because he went to a lawyer, a personal lawyer, and said, I believe I could be personally responsible for suborning a miscarriage of justice here because I'm aware of these things, and my employers, the prosecutors in this case, are not turning it over even though it appears they are supposed to.
Could that be a mistrial then?
Well, what happened was they did turn it over at the very 11th hour, and of course the judges said you can't use most of it. But here's what happens, and this is exactly what the government did in a high-profile trial I was in. Dump everything on the defense attorneys on the eve of trial so you don't have time to research it, develop it, and see where it leads, okay?
Right.
I mean, they had the chance to do that, but then they don't want you to have the same chance. So what they did was they held on to this stuff, and only when they were caught with their hand in the cookie jar, because this guy's lawyer then went to the defense's lawyer, and then they went to the judge, did the prosecution turn it over. And, of course, she denied a continuance on that basis. And then said, well, we're not even going to get into whether it was prosecutorial misconduct until after the trial is over or not. So there shan't be any sanction. We shan't tarnish the prosecutor's image in any way or let the jury on to that they might have actually be dealing dirty in this case.
Oh, that's wrong.
Right, that's what I think, too. So you've got all those things. So you know what they did to the guy? They fired him on Friday. After the case went to the jury, he gets a letter that says, you're fired. And why is he fired? Because he leaked that his bosses were hiding evidence in the Zimmerman trial. Right?
There's a lawsuit.
So, well, yeah, I'm sure it's a whistleblower lawsuit, but here's the deal. What's the message? What's the message to all the little guys? If you work in a state police crime lab, if you work in the district attorney's office and you find out your boss is hiding evidence or cooking the books or doing something in a trial to convict somebody unfairly or at least denying them a fair trial, you're supposed to look the other way because otherwise you're going to get fired. That's the word on the street, right?
Yeah.
So there's a lot of problems in the trial. Also letting the district attorney after, closing arguments add a new count or close of evidence add a new count. Really should have been done earlier if it was going to be done so that the defense could try their case around it.
How do they prepare for that?
What the judge did was basically give the government a bone and say, oh, it looks like the defense has made some strong arguments on this murder, too, with this self-defense angle, so I'm going to give you a back door for you to try to make sure you can still get a conviction. And then we've learned this week that the Department of Justice was down there, the Obama administration, but our Department of Justice through Eric Holder, spending money on rallies and organizing protests in this trial, whipping up public opinion against Zimmerman.
Yeah, I read that.
Completely inappropriate. And as we know, this prosecution wasn't brought until sufficient political pressure was created that the state of Florida bowed to it and decided to do it. Otherwise, this poor guy would have never been charged in the first instance.
Yeah, didn't the original sheriff who didn't want to bring charges because there wasn't a case he felt fired or something?
Yeah, they fired him. Then after they got this thing back, they somehow got him reinstated, I think, because obviously they really couldn't fire him for this, for exercising what I would consider to be very sound discretion.
Yeah.
So listen, here's and let me just tie this into the whole Snowden thing here for a second.
Yeah.
We've got this whole back room going on in government right now, okay? This whole back room going on where we have a grand jury proceeding process here in Pennsylvania, but they can't tell us what they did. They can't show us what they did. And one grand jury judge and the state attorney general's office can know the truth, but you just have to trust them. Just trust them, okay? Just like the government now goes in front of Congress and lies about what they're actually doing or not doing, and then says, well, national security requires us to lie to the congressman. Well, so you have no overview by the legislative branch. Well, now in this trial, we've got all these outside pressures coming to bear, and whether or not this judge is truly ruling from her heart and her intellect, or whether she's bowing to the pressure as well, going, oh, but I've been told that if there's an acquittal, we're going to have a race riot, so I need to make sure, whatever I can, to make sure that he still gets convicted of something, Is that going on? The answer is probably not, but we live in an environment now where we can't be sure because all the way down from the President of the United States comes the pressure.
Yeah. And tremendous pressure from the media, too.
And if you go on Twitter, if you want to do something really interesting, go on Twitter and follow the commentary on the trial, because you can just use like hashtag Zimmerman trial and you can see in real time what people are posting. And look at this reminds me of the O.J. Simpson case. There is definitely a huge racial divide in how people feel about this case. African Americans as a whole on the Twitter feed are pretty sure that that Zimmerman should be convicted. A lot of other folks on the other side, and there's clearly a racial divide if you just look just at the Twitter feeds, okay?
Yeah.
Keeping in mind what the relative percentage of the population is of minority and Hispanic. And now he's a white Hispanic, by the way. I don't know what a non-white Hispanic is versus a white Hispanic, but apparently, according to the media, we now have distinctions. It reminds me of... we're getting like in Latin America for many years, there's 18 different ways to divide up somebody's ethnic history.
Well, there's something that really has really surprised me, and that is there are several very large Latino groups, La Raza being, I'm not sure, but I think that's the student one, and there's some others, and they've been virtually silent on this. I mean, if there are race riots, if he gets a very minor conviction or nothing at all or acquittal, I think there's going to be a lot of trouble between the black and Hispanic groups. But I'm surprised that they haven't spoken up. Geraldo is the first one I've actually seen.
Well, actually, I'm going to give the Hispanic groups credit. And what I mean by that is I'm going to give them credit for saying it isn't a racial issue.
Right.
And for saying that this is just about what happened between two men, one who happened to be black and one who happened to be a light-skinned Hispanic, and what really happened.
But the only thing is that because the other groups like Al Sharpton and all these others, and even the BET guy and his big mouth, I don't know if you've seen that, which I responded to, but anyway, they are making it a racial issue, so I'm surprised the Latinos haven't responded by saying, hey, what are you doing? What's going on? This is,
Yeah, and I understand that, and maybe there should be some response. On the other hand, the best way to get race out of politics and race out of the law is to stop making it an issue. Yeah. And the only thing we can do is say to that, I think sometimes maybe the better argument is to say, you should not make race an issue, therefore we won't either. But if you guys are going to make race an issue, we're just going to keep saying it's not an issue, but we're not going to do it from a racial standpoint. But I do find it just interesting that the media has worked so hard. I guarantee you that if we quizzed a third of Americans, they'd probably swear up and down that Zimmerman was white and not even know that he's Latino.
Yeah.
Now, and that's also because his last name's Zimmerman. He sounds like a German.
Right.
All right, my friend.
Maybe he was related to Adolf.
Yeah, exactly. All right, I'll talk to you soon.
All right.
All right, man. Take care. 540-0580. Carl Rominger will be back.
Let's return to Weekend Appointment with Carl Rominger on WHP 580.
Well, welcome back. Carl Rominger here, 540-0580. Mark, you're on WHP 580 with Carl. What's going on?
Hey, Carl, thanks for your time. Hey, I'm working with a purge title. Here's what I think I know about it. I think what I need to do is I'm in Lancaster, go to the Lancaster County Courthouse, get the appropriate form or paper, fill it out, and then I have to go in front of a judge and explain to the judge how I obtained this vehicle and so on and so forth. And then the judge makes a determination of whether or not everything's legitimate, which I'm sure everything is. Otherwise, I never would have gotten involved with this. But,
okay.
The paperwork, is that something I've talked to an attorney. It's really expensive. In the past, what I would do is just I could send out of state and get a title from out of state, and it worked well. But that's all changed over the last couple of years.
Mm-hmm.
So for me to do the paperwork by myself, is it something that's realistic, or am I going to get bogged down?
Well, I mean, the paperwork to do it in a court with a judge, there really isn't a piece of paper, if that makes sense. You have to file a petition with the court that basically says, here's the situation, here's what I want to do, Judge.
Okay.
And so in that respect, there's not like a form to fill out to file with the court.
Okay.
It's and how you title it, I'm not sure who the respondent is there. It might just be in Ray, a white Ford Chevy.
Well, I mean, like I said before, I'd send out a state, and then I would get an out-of-state title, take that to PennDOT, and then I would just get a PA title. But it's like I said, it's all changed, and it isn't something I guess I'm just coming back to my initial question. I mean, can I do this? Can I petition the court?
Yeah, I don't see why you couldn't.
Okay.
I don't see why you couldn't. So I just wouldn't know how to describe the form of it to you, except to say, just the same way I write a lawsuit. Basically, you're going to write a petition, and it's going to have in it all the essential facts. Here's this vehicle. Here's what I want to do with it. Here's how I got it. And here's what PennDOT needs, an order from your judge.
Yeah.
And then you do an order. And if you go to the PennDOT website or talk with PennDOT directly, they may be able to tell you exactly what they need the judge to order.
Okay.
That usually pays. Now, see, it's a little bit of a cheat when you're a lawyer, and what I mean by that is I can call the other counsel. So a lot of times if I'm dealing, like, say, with the state police on an issue and like somebody's gun rights or something, I can call counsel over there and say, hey, here's what I'm thinking. Is that what I should file? And he'll say, no, you're wasting your time and my time. I don't want to have to deal with that. What you should file is this. And then we can have a real hearing over it. Or there's no way you're going to win that ever, and let me tell you why. I have a case that says that, so I'll just send it to you now. And people may go, well, why is the one lawyer helping the other lawyer out? Well, what we're doing is helping everybody out, because his client, the state police, or the agency for whatever it might be, or PennDOT, doesn't really want to pay him to go to court to defend something frivolous, right?
Right.
And you don't want to pay me to do something frivolous. So the lawyers try to hammer out realistically where we're at. And, of course, here it's not...
the right thing gets done.
Right thing gets done. It's not two individual parties who are just having a fight over spite fence either.
Well, see, now I was given a suggestion to contact, like, the 4 previous owners' name is on the title. Like I said, I had the title, but it wasn't notarized by the previous owner when he sold it to the person I bought it from. That's how stuff was done back then. It's an old vehicle, and actually it's a pre-1972 title, which of course all the titles before 72 were wiped out in Hurricane Agnes flood.
Right.
But the suggestion I was given when I went to the Notary Public was to contact the previous owner. His name is on the title. Of course, he's long since gone. And I went down through the phone book and I tried to contact everybody from the area that he was from. And of course, I came up with nothing. If I could just find him or find the person that had power of attorney to his estate, then I'd be home free. But that's just there's nobody around. There's just. So it seems like I have to go in front of a judge with this petition as you're talking about, and then pretty much the judge just, I'll contact PennDOT like you were saying too.
Yeah, and what the judge will usually do is have a little hearing, put you under oath, right?
Right.
Because that creates the idea that you're probably telling us the truth because there's a real penalty now.
Right.
And later if it turns out you weren't and somebody can prove it, you might be in trouble. But the point is that creates a verification procedure because that way PennDOT can rely on the judicial order. And if somebody else comes back and says, well, what happened to my car?
Well, it's a motorcycle. It's not a car.
Right. Okay. Motorcycle. Right. What happened to my vehicle?
Yeah.
PennDOT says, well, a judge extinguished your rights. And then they can come back and find out, what you said. And it's pretty frequent that these things happen. I mean.
Okay. Well, like I was saying before, it just in the past, but prior to the old green titles, prior to 71 or 72 is when Agnes was. Prior to then, you could send out a state. Now, after 72, the state wouldn't do that because there was documentation, I guess, was there. It was easier to the state had a better record of it. But
right.
This is just the last time I did this was like in, I guess, 98 or 99, and that it was only a couple $100, But now it's not as sure to just send it out of state, and that's why I wanted to check and see what's up with with the Birch title. So okay, all right. Well, I'll start with PennDOT, and then just see what I guess I'll go to the courthouse and see what's involved there, and if it's something I can't handle, I'll give you a call.
All right, keep me apprised.
Okay.
All right, my friend. Take care.
Hey, thanks, Carl. Bye.
540-0580. Carl Rominger here answering your legal questions. Billy.
Hi, Carl.
Yeah.
Hey, question for you. I have a small pistol always kept in the glove box in my car. Well, about 3 days ago, I went into my car just to take it out and clean it, and it's missing. What are my responsibilities and my liabilities towards
Well, under Pennsylvania law, there's no mandatory must report a stolen gun, okay?
I can't prove it was. I do believe it was, but it's missing. So it wasn't like my car. I'm saying my car window wasn't broken or something like that.
I would go to your local police department, and if you don't have a local police department, it's the state police.
Okay.
If your municipality is living off the fat of the state, so to speak, so you go to your local police officer and you give them a report. Here's my gun. Here's a description, and if you have the number, obviously it helps.
I do, sure.
And report it missing, and say, I'm not certain, but I would think it was taken because nobody should have had access to it.
Yes, sir.
They might ask you some crazy questions like, well, did you leave your car unlocked and that sort of thing?
Right.
And the answer is going to be, well, of course not. I had a gun in it.
Right.
And I would counsel against leaving a car unlocked with a gun in it because there may be an argument when two kids shoot each other later that somehow you negligently gave them access to a firearm.
I see.
Whereas the car was locked up, you can't expect somebody to break into your stuff.
Right.
Okay. So anyhow, after dutifully explaining to the police that you always keep your car locked with the gun in it, if you had your gun in it, and they can give you some guff, but I don't think there's an issue here. Like, wow, why do you keep a gun in the car? Well, because I have 10 guns and I want to keep one in my car. None of your business, all right?
That's exactly right. Yes.
But once you report that way, if that gun shows up somewhere, they'll be looking for it and it'll work its way back to you, which is also nice.
I got you. Okay.
All right.
Hey, thank you. Appreciate it, man. Love you.
Now, technically, you don't have to tell anybody, right?
Okay.
Just want to make sure you know that. On the other hand, if that gun gets used somewhere and that number comes back to you because it's registered to you, and of course the state police do keep a registry, even though our Supreme Court doesn't call it a registry.
Understood. Then they're coming looking at me first.
Right. You're going to be the first guy that's suspected of shooting somebody. And when it turns out to be a girl you used to date, then you're never going to be believed.
Understood.
All right.
Hey, thanks a lot. Appreciate it. Again, your show's great.
No problem. Thanks. 540-0580. We're going to go to break right now. When we come back, we're going to talk to Dennis and Natasha.
Return to Weekend Appointment with Carl Rominger on WHP 580.
Welcome back. Let's see. So, once in a while when listeners are far-flung, they let me know how far away they are and they're listening. So far, the farthest I've got is Maui. And I mean Maui like Hawaii, like Magnum PI territory. When I think of Hawaii, I'm going to be very disappointed that there's no Magnum when I get there. But I still love that show. And, has anybody figured it out? Is Robin Masters really Higgins? Do we know? Did we ever get an answer on that? I would like to know. I have all kinds of questions today. Anyhow, 540-0580. I want to remind you guys, if you want to hear the Carl versus police officer debate, go to RomingerLaw.com. It's the first thing up under the news there still. Braxton Diddy was kind enough to come on the Durgan show. I think he subsequently hosted it as well. And we did a little debate about police and lawyers, and it was pretty good, I think. Also, I might try to get my mom in the next hour, see if we can get a new recipe out of her, because we haven't had a recipe in a while, and I think she owes us that. Right? Owes it to me. Hey, Mom, I'm 40 and I'm moving back in. I want to let you know. By the way, you have a recipe? Yeah, she'll love that. Dennis, you're on the air. What's going on? Hey, Dennis.
Hey, Carl. Thanks for taking my call.
What's going on?
About 5 years ago, my father-in-law's house burnt down. He took the money and some of the money, and he bought a house, and he put it in my wife's name mainly because he was in fear of the IRS coming after him for not filing taxes, and he didn't want to lose it. So the house is in my wife's name. My wife and I are getting a divorce. So my question is, do I get half the house because it's in her name and it was acquired while we were married?
The short answer is it's presumptively marital property. And courts struggle with this issue when somebody comes in and says they're really holding the property for the benefit of somebody else. So I would say you can make a big issue out of it and you might prevail, because I'm sure that your wife's not going to want to testify that she was part of a scheme to defraud a government agency.
Right. She'll what would you call it? It's not an inheritance because he's still alive, and I was just curious about that. I do have an attorney right now, and I
think you can make a really strong play for it.
Okay. Thank you very much, Carl. Appreciate that very much.
All right, boss. Yeah, I remember a case years ago where the guy he was in the middle of his own divorce, so he put like $200,000 in his mother's name in an investment account. And, of course, after he'd finalized his divorce, but before he'd bothered to shake mom down for the $200,000 back, she died. And, of course, he's floating around trying to say that $200,000 of mom's money, which was a large portion of her money when she died, by the way, was really his. And, of course, his 5 brothers and sisters were saying, well, that's not really true. I mean, it wasn't mom's account, and you wouldn't have gone to the divorce court and said that you would have told the divorce court that was your money, because here's your testimony from your master's hearing where you said this is your net worth. So it doesn't think it's yours. I think it gets divided 6 ways. So, you run into these problems. Natasha.
Yes, hi. Thanks for taking my call.
No problem.
I spoke to my husband. He got a ticket this morning for not having the registration sticker on the back of the car.
Okay.
A $112 fine. Now, the question I have, is it worth even going to court to fight that? I mean, registration's valid.
I mean, the answer is if the police officer's willing to give you a break, right? But since he already wrote it, I suspect he's going to say there's nothing to plead it down to. It's like a lowest tier offense as it is, right?
Yeah.
So, and he wrote it, which suggests it wasn't his intent. The answer is you could go to the hearing and ask the judge to dismiss it, and maybe they will, maybe they won't.
Okay.
What's the excuse?
The excuse for not having it on the car?
Yeah.
I didn't know it wasn't on there.
You just forgot to put it on?
Generally, my husband deals with that stuff, and I never look at the back of the car. So, and I mean, he said because of the fact that it's coming up for renewal next month.
Right.
And so he said, you've been driving for long enough without it. But the thing is I heard, funnily enough, I have been pulled over for it before, but I never got a ticket, and I did not know that you could get one. The officer never said to me, you need to have it, you'll get a ticket without it. It was just, oh, okay, and he gave it back to me. And so
the short answer is make sure it's on there next time. And it sounds like you already got a couple breaks, which is fine.
Yeah, I know, stupid me.
So now, I have to ask you this, right? So your name is Natasha, and you're from Pennsylvania.
Yes.
So have you ever watched Rocky and Bullwinkle?
I'm actually not American, and I never was over here when they had it on.
Okay, well, you're going to have to go on the internet and watch some old, because Natasha and Boris are from Pennsylvania, and they're the foils in the show.
Okay.
So I'm going to guess your husband's name's Boris. Now I find out you're from out of country, so it's even more likely his name's Boris or Block or other European name.
Well, no, he's American.
Oh, okay. That's how you got here.
No, my parents brought us.
Oh, they brought you over.
Well,
I'm first generation.
My life now.
I was born here, but my mom and my dad were not born here, so I'm not more American than you.
So you're first generation.
Yes, I'm first generation. So I'm still working hard. I can watch my grandkids get lazy.
That sounds good to me. I'd rather be the lazy one. Well,
yeah, me too. But
the sticker on the car, did I?
Well, right, you've accomplished your goals. That's good.
There we go.
All right, Natasha.
All right. Well, thank you very much. I appreciate you answering my question.
All right, thank you very much. 540-0580. Yefe. Jeff, what's up?
Yes, Carl. I've been watching the Zimmerman trial with pretty great interest. And I've said since the very beginning, well, not the very beginning, but as it was going on, I thought, man, if this isn't reasonable doubt, I wouldn't recognize it. But I'm not a lawyer, so I thought all along. And the more it went on, I thought, well, that's what it just looks that way. But anyway, on the news today, now they're saying that and maybe you've had a caller. I just tuned in a little while ago that says that the prosecution has fired the IT man who testified that the prosecution didn't give all the evidence over the defense. Okay, now you're a defense attorney. Now they're in deliberations. What's a possible scenario that could come out of this?
Well, here's what happened.
That he's telling the truth and that there was some stuff that wasn't put out in a timely manner or held back or whatever.
The defense got it already, okay? And they got it, but not too long before the trial started, and the judge refused to delay the trial on that basis.
Okay.
But here's the problem. I mean, here's the bigger problem, and I mentioned this earlier, and I'll say it again. So he's in trouble because he refused to cover up for his bosses. He refused to go along with what they did. And if you think for a minute that prosecutors don't hide discovery, now, here's the answer. There's a little bit of gamesmanship in trials, okay? And I'm guilty of it too. Will I take a position sometimes where somebody would say, well, his position's a little unreasonable, or you know, they got to get a judge to kick me in the butt once or twice, whatever. And prosecutors do the same thing, and you expect it, and nobody cares because that's just the way it's done. But there are lines you can't cross. And interestingly, for prosecutors, they're supposed to ethically provide all exculpatory information. It's a little different from a criminal defense attorney. I don't always have to provide incriminating information to the other side, okay? Mm-hmm. But they always have to provide things that are exculpatory, which tend to prove innocence. That's called the Brady Doctrine. The United States Supreme Court established it many, many moons ago. So for them to hold on to this is just purely unethical and illegal. And
one of these so-called experts, when they were talking about this, said that you could actually get, he said unlikely, but you could actually get prison time for doing this.
Yeah.
But,
And so,
by the way, just as an aside, I'll let you go. I thought of you during the trial when they had this the lead detective, and he was questioning Zimmerman. I think it was like the third time or whatever. He said, we got the victim's phone, and this is on, on well, I'm going to say film, but this is a video. Mm-hmm. And Zimmerman said, good. I think he threw the guy off. He said, good. That'll prove it. I'm telling you the truth.
Right. And see, now, of course, Zimmerman did something we wouldn't account. If he'd hired me, like the minute this had happened, I would have locked him down and I wouldn't have let him go on Hannity.
I'm sure any defense attorney would say, don't go in there and talk to them.
On the other hand, if you're going to do the police interview, this guy was pretty good, right? And you're right. All the indicia is, and the other thing is, I keep hearing this one. This is what they've dumbed this down to the point where everybody says, he was told not to follow him, therefore he wasn't where he was supposed to be. The actual tape, the 911 operator just says you don't have to follow him. We don't need you to follow him. Yeah. Not you can't, you shouldn't, don't, stop. It's we don't need you to do it. That's great.
But if you're going to be a neighborhood watch, going back to your car and going home isn't really effective. But that's sort of
I saw
a little the nitty gritty of it, and I understand people say, well, if he'd have stayed in his car, if he'd have stayed home and not gone for groceries. If Trayvon would have stayed where he was, all these ifs have nothing really to do with anything.
Let me just tell you, we call it the but-for test, okay? And so, but for the fact that you ran the stop sign, I wouldn't have had a car accident, right? Yeah. But for the fact that your parents had sex, you wouldn't have run the stop sign and I wouldn't have had the car accident. And but for the fact that your great-great-grandparents met at the cotillion, you wouldn't have existed and your parents wouldn't have sex and you wouldn't have run the stop sign. So you can use the but-for test to pretty much go all the way back to, and it's really, but for Eve being tempted by the serpent, we'd all still be living in a paradise, right?
Yes. Well, and interestingly enough, when the defense was saying what you got to go by the facts, and the prosecutor in his final whatever you call when they give their final word,
right? The rebuttal.
Yeah, the rebuttal part. He says, now use your gut and your heart. And I'm thinking this guy just stood up and said what the defense says you're not supposed to do. He's pleading for him because I think their case is so weak. Anytime
you hear a prosecutor say, use your common sense, everybody out there, if you're ever in a closing and you hear the prosecutor say, use your common sense, that's an appeal to avoid the facts, avoid the burden. We wouldn't have charged him if he wasn't guilty. Use your common sense. So if you ever hear a prosecutor say common sense or gut or heart, you know what they're doing.
Okay. Well, hey, we could go on about this, but I know you have other callers, and I appreciate your time.
All right, boss. Thanks.
Okay, thanks.
540-0580. Carl Rominger here answering your questions. Harrisburg Beer and Cigar. Great place to go, right over on Union Deposit Road. Stop in, tell them I sent you. Got a $500,000 collection of cigars in there. Absolutely amazing. And, of course, a great beer selection as well. When we get back, we'll talk with Dan about the Attorney General and Barry about some property. See you guys in a minute.